Good evening from New York. I'm Chris Hayes. Well, the tenure of the worst Secretary of Homeland Security since the agency was formed has come to an end in spectacular and humiliating fashion. Kristi Noem, and we assume her special government friend Corey Lewandowski, are out. Fired today on Truth Social by Donald Trump, quote, "The current Secretary, Kristi Noem, who has served us well and has had numerous and spectacular results, especially on the border, will be moving to be special envoy for the Shield of the Americas," a thing I didn't know existed until today. "Our new security initiative in the Western Hemisphere we are announcing on Saturday in Doral, Florida. I thank Kristi for her service at..." He also announced her replacement. That would be current Oklahoma Senator Markwayne Mullin, the guy who has been all over cable news in the past week for some reason, although we all know who else watches a lot of cable news. He may be no better, but tonight is for reflecting on the end of Kristi Noem's ignominious cabinet career.
Let me start by telling you what actually happened, because there are versions of this story circulating online that describe immediate arrest warrants, marshals showing up tonight, Trump being taken into custody right now. Those versions are not accurate. What Judge Juan Merchan actually did is something that requires more careful attention than the dramatized version, because it is, in certain respects, more consequential than the dramatic framing suggests. Merchan has not signed an arrest warrant. He has not ordered Trump jailed. What he has done, and what makes this a genuine constitutional and historical moment, is warn explicitly on the record in a formal written contempt order that incarceration is the next tool available to him, that the fines have formally failed as a deterrent, and that he is prepared to use that next tool. Okay, now let's get back to the video.
She made it 14 months, almost exactly as long as Cricket, the dear departed dog she bragged about shooting in her memoir. Kristi Noem's tenure is ending in complete humiliation. You could see from the look on her face this week as she was grilled by members of both parties, she very much looked like someone who knew she was in danger of losing her job. And you could be forgiven for finding it all satisfying, considering just how corrupt and vile DHS has been under Noem's watch. In the Salvadoran gulag, where she deported hundreds of men with zero process, using them as props as they rotted behind her while the gold Rolex on her wrist glinted in the light, to staging elaborate photo ops of herself armed and on fast boats and joining raids to create social media content, to slandering Renee Good and Alex Preddy, Americans who were shot and killed in broad daylight on camera by her masked aide.
And then, because the documentary dimension of this story is as significant as the warning itself, the New York City Department of Correction publicly confirmed that they are aware of the possibility and would make any necessary arrangements if Merchan actually issues that order. The city jail system is already doing contingency planning for the possibility of incarcerating the President of the United States. That is documented reality. It is not speculation, it is not dramatization, and it is, in its quiet institutional way, more significant than the viral arrest warrant headlines, because the Department of Correction does not do contingency planning for things it considers far-fetched. Let me walk you through exactly what has happened, what the legal predicate that Merchan has built actually means, what the institutional signals tell you about how seriously everyone involved is treating this, and what one more deliberate violation would actually trigger, given everything that is already in the record. Let's start with the documented record, because understanding what 10 contempt violations and 2 formal judicial findings mean as a legal predicate is essential to understanding why Merchan's warning is different from a routine judicial admonition. The gag order Merchan issued was specific in its scope and its purpose. It barred Trump from making public statements attacking witnesses, jurors, and certain court staff connected to the case. The logic is elementary. Witnesses who face the possibility of being targeted by a public figure with tens of millions of social media followers may choose not to testify, may soften their testimony, or may experience real personal danger. Jurors who are publicly identified and attacked may be unable to deliberate freely. Court staff who are subjected to social media pressure may be unable to perform their functions. The gag order existed to protect the integrity of a legal proceeding. That is not unusual. Judges issue gag orders in sensitive cases as a standard tool for protecting the process. What is unusual is that Trump violated it 10 times. Each violation was documented, adjudicated, and entered into the formal contempt record. Merchan fined him $9,000 in one ruling, $1,000 in another. And then Mershon wrote in a formal order the sentence that changes the legal landscape of everything that follows. The $1,000 fines are not serving as a deterrent. That sentence is not rhetorical. It is a formal judicial finding that the standard contempt remedy has failed. In the normal operation of contempt law, fines are the first tool because they are usually sufficient. When a judge formally finds that fines have failed, when the party being fined has continued the violating behavior despite the financial consequences, the next step in the contempt escalation is incarceration. Mershon did not just threaten incarceration. He formally documented the failure of the lesser remedy, which is the specific legal predicate that justifies escalation to the greater one. The record he has built is methodical and deliberate. Every element that a reviewing court would examine to assess whether an incarceration order was properly justified, documented violations, documented inadequacy of fines, formal written warning, is already there. What is missing is the next violation. Now, let me explain why the specific language Mershon used in his written order is the most analytically significant element of this story. Because, if necessary and appropriate, is not a vague or conditional phrase in the context of what is already in the record. Mershon wrote that the court will impose an incarceratory punishment if necessary and appropriate, not if Trump does something dramatically worse, not if there is some future escalation beyond what has already happened. If necessary and appropriate based on the continued pattern of what has already been occurring. A judge who has already found 10 violations and formally concluded that fines have failed as a deterrent is describing the existing pattern when he writes continued pattern. He is not setting up a distant hypothetical. He is describing the situation that already exists and saying, if this continues, incarceration is the response. The practical implication is specific. Every element required to justify an incarceration order is already documented in the record. The violations are documented. The inadequacy of fines as a deterrent is documented. The formal written warning is on the record. What is left is one more violation that Mershon reads as willful, one more deliberate act that he determines crosses the threshold from fine-worthy to incarceration-worthy in his assessment. And the threshold is lower than it was before any of this started. Because the established pattern of willful violation, despite documented fines, is itself the context within which the next violation will be evaluated. Mershon also said something in open court that deserves its own careful attention. He told Trump, "The last thing I want to do is incarcerate you." He acknowledged the extraordinary nature of what he was contemplating. He acknowledged who Trump is and the weight of the decision. And then he said, "But I have a duty to uphold the integrity of this system." That framing, personal reluctance acknowledged and then set aside because of the duty, is not judicial performance. It is the documented reasoning of a judge who has worked through the weight of what he is contemplating and arrived at the conclusion that the duty does not bend because of who the person in front of him is. Let me address the New York City Department of Corrections' public statement. Because this is the most institutionally significant element of the story and the one that tells you most directly how seriously the people who would have to execute an incarceration order are treating this possibility. The Department of Correction publicly confirmed that they are aware of the possibility that Mershon could order Trump jailed for contempt and that they would make any necessary arrangements if that order comes. Professional law enforcement institutions do not issue public statements about making necessary arrangements for hypothetical events they consider far-fetched. Contingency planning is expensive, time-consuming, and institutionally significant. The doc does not plan for things it thinks will not happen. The statement means exactly what it says. The people responsible for executing a potential incarceration order are treating it as a genuine possibility that requires preparation. What does that preparation involve? Where does the President of the United States go if a judge orders him held in contempt? What facility? What security arrangements? What does the cell look like? What happens to the presidential motorcade? What does the process of intake look like for the most protected individual in the country? These are not rhetorical questions. They are operational planning questions that someone has to answer before the order comes, not after. And the doc's public confirmation that they are working through those questions is the clearest available institutional signal that this is being treated as a real possibility by the professionals closest to it. Halfway through. If the completed legal predicate, the if necessary and appropriate language as non-conditional given what is already in the record, and the DOC contingency planning as the clearest institutional signal are giving you the most accurate available picture of where this actually stands. Leave a like right now. 2 seconds. And drop a comment. If Merchan issues an incarceration order, do you think the Secret Service complies, or does the constitutional collision between its protective mandate and the court order produce its own separate constitutional crisis? Tell me below. Let me address the Secret Service dimension, because the collision between the Secret Service's constitutional mandate and a court order directing that the president be taken into custody is itself an unresolved constitutional problem that has never been confronted in the history of the Republic. The Secret Service's mission is to protect the president at all times. That mission is statutory and constitutional. Secret Service agents are legally obligated to protect the principal they are assigned to regardless of the circumstances. A state court contempt order directing that the president be taken into custody does not contain a Secret Service exception. It is a judicial order directing that a specific person be held in a specific facility under the custody of the court. If Merchan issues that order, the Secret Service faces a question that has no pre-existing protocol. Do you comply with a state court order directing custody of the individual you are constitutionally obligated to protect? Do you accompany the president into the facility? Do you maintain your protective perimeter inside the jail? Do you interpose yourselves between the president and the court's custody authority? These are not abstract questions. They are live operational questions that the Secret Service has to answer if the order comes. And the answer has implications that extend far beyond the immediate contempt situation. Because whatever the Secret Service does in response to Merchan's hypothetical order sets a precedent for the relationship between the judicial branch's contempt power and the executive branch's protective obligations. The DOC's contingency planning presumably includes some coordination with the Secret Service about how this would work. But the fundamental constitutional question, can a state court contempt order override the Secret Service's protective mandate, has never been resolved, and it would need to be resolved in real time if Merchan pulls the trigger. This is one of the dimensions of the situation that makes Merchan's position so genuinely extraordinary. He is not just deciding whether to jail one person. He is potentially triggering an institutional collision between two different legal obligations that have never before come into direct conflict. Let me address the constitutional immunity dimension, because the question of whether presidential immunity bars a contempt enforcement order is actually one of the more cleanly resolved legal questions in this entire situation. Presidential immunity, as the Supreme Court defined it in Trump versus United States, covers official acts taken in the exercise of presidential power. The Supreme Court was explicit. Private conduct taken in a personal rather than presidential capacity, receives zero immunity protection. The gag order Trump has been violating arose from a state criminal trial over conduct that predates his current presidency. The hush money payments, the business record falsifications, these are pre-presidential personal conduct, not official acts, not exercises of presidential power. Private conduct, criminal contempt for violating a gag order in a state criminal trial over pre-presidential private conduct is not an official act. It is enforcement of a judicial order against private behavior by a private individual who happens currently to hold the presidency. The Supreme Court's immunity framework, as written, does not protect this category of conduct. There is no immunity for the hush money conduct itself, which is why the state trial proceeded. There is no immunity for violating the gag order connected to that proceeding, which is why the contempt findings have been sustained. And there is no immunity argument that would obviously bar an incarceration order connected to those contempt findings. Trump's legal team would file emergency motions. The appellate proceedings would be unprecedented in their speed and scope. The constitutional questions would multiply in real time across every level of the judiciary simultaneously. But the core legal predicate that a sitting president is not immune from contempt enforcement in a state court proceeding over unofficial pre-presidential conduct is on relatively solid ground given what the Supreme Court has already said about the private conduct category. Let me close with the most analytically significant dimension of where things actually stand, because one violation away is not a rhetorical formulation. It is a precise description of the legal situation, given everything that is already in the record. Merchan has done everything short of signing the order. The violations are documented. The inadequacy of fines is formally found. The warning is on the record. The institutional contingency planning has begun. The constitutional questions have been mapped. What remains is Merchan's judgment call about whether the next violation crosses the threshold from fine-worthy to incarceration-worthy. A judgment call he has already formally indicated he is prepared to make. And Trump's own conduct creates the specific risk. The gag order bars him from attacking witnesses, jurors, and certain court staff. Trump has a documented history of using his social media platform to target people who are testifying against him or participating in proceedings where he is a defendant. The pattern that Merchan formally described as a direct attack on the rule of law is not historical. It is ongoing. And every post, every statement, every social media attack on anyone connected to the proceedings is evaluated by a judge who has already found 10 violations, already concluded that fines have failed, and already told Trump directly that the next tool is jail. The political earthquake that would follow an actual incarceration order, every Republican facing the most intense pressure of their careers, the constitutional arguments exploding simultaneously across every court and every media channel, the international reaction, the 2026 landscape redrawn overnight, would trace directly back to a pattern of behavior that Trump chose 10 violations at a time in defiance of a judge who warned him repeatedly and clearly. Merchan said the last thing he wants to do is incarcerate Trump. He said it directly. And then he said he has a duty. That duty, articulated in a formal court order with 10 contempt violations behind it and a documented failed deterrent already on the record, is the specific constitutional moment that Kristi Noem's firing on Truth Social happened to share the news cycle with. One more deliberate violation. That is the gap. You just got the most accurate available breakdown of what Judge Merchan actually did. Not the viral arrest tonight dramatization, but the documented legal situation. The completed predicate of 10 violations and formally found failed deterrent. Why, if necessary and appropriate, is not a distant conditional given what is already in the record. Why the NYC Department of Corrections contingency planning is the clearest institutional signal about how seriously this is being treated. What the Secret Service collision between its protective mandate and a court custody order would look like. Why the immunity framework leaves contempt of a gag order over pre-presidential private conduct, specifically unprotected. And what one more deliberate violation actually means for a judge who has already done everything short of signing the order. One more violation. The predicate is complete. The warning is on the record. If this gave you something real, do 3 things right now. Leave a like, 2 seconds. It keeps this accurate analysis reaching people who deserve the precise picture of where things actually stand rather than the viral dramatization. Do it now. Subscribe and hit the bell. Merchan is holding the pen. Trump's next social media post is the variable, and every development in the contempt proceedings changes the situation. When the next moment breaks, you need the breakdown immediately. Subscribe now. Drop a comment. If Merchan issues the incarceration order, do you think the Secret Service complies and accompanies Trump into custody? Or does the constitutional collision between its protective mandate and the court order produce its own separate crisis? Tell me below. Share this with someone who saw the viral Arrest Tonight version of this story, because what Merchan actually did is more carefully constructed, more institutionally significant, and more constitutionally consequential than the dramatized version suggests. I'm Thomas Keller. See you in the next one.